Hi guys! Hope everybody is doing well on this Saturday. It is extremely hot in Florida. Hope everyone's getting ready for Memorial Day weekend if you're getting together with your friends and family. If you're, overseas, one of our friends in another country, hope you just have a good weekend. We're going to be doing some Courtney Clenney updates. So last time we got together for a Courtney Clenney stream, it was because her team had officially filed their motion to disqualify the Miami-Dade State Attorney's Office. Now, back in February of this year, the lead prosecutor on the case, Khalil Quinan, the defense had motioned they wanted to depose him, and right before they did depose him, he withdrew from the case. Now, the defendants, Courtney Clenney and her team, are arguing, look, him stepping down voluntarily doesn't cure the problems. And they made two arguments in that motion to disqualify. I think it's pinned in the chat. It's linked in the description if you want to go through that live stream. But in short, the two arguments were the prejudice to Courtney Clenney and her defense and substantial misconduct. So those were the two avenues that they argued. We're going to do a quick docket check and we're going to read this filing. I've got a few videos, some stuff I want to show you guys as we go through. There is a poll, so if you're watching this live, please use the poll or enter in the chat. If you're on replay crew, leave a comment. Do you think this trial is going to happen in 2025, or do you think it's not going to happen in 2025? You guys can probably guess my answer, but I want to know yours. Over here on the docket, next hearing. So if you want to follow for some updates, we've got all the way out at June 25th. So more than halfway through the year. And this hearing is going to be for the judge to come to a conclusion on this motion to disqualify. So that will be a pretty big day. I don't know if it'll be anything with an actual televised hearing or if we'll just get the news. As far as the docket, really, really awesome. They've started to make it accessible, the key documents. So this was the motion to disqualify. This is the reply that we're going to be reading from Clenney. They didn't upload the state's response, and I didn't get an email with a copy of it. I didn't get a response from them yet. So hopefully they'll put this in there. But if you notice, they've never gone ahead and uploaded documents like that before. So I don't know if they're getting tired of people like me asking them, but I do think it's really nice that it's a bit more accessible. So what are they saying? What are they saying? And again, this is the defense reply to the state's response. So we're going to get some context on what the state was arguing. I don't have that full filing. I never got a response. We'll see if we get it. But it does give us, if we take this at face value, it'll give us some context on what was argued or wasn't argued in the state's reply. Because they're obviously saying, don't disqualify us, Judge. Don't disqualify us. Big shout out here. Dolly Talk was here 2 hours early. It's so good to see you. If you're still in here, okay, you're not streaming. Tomorrow, you're probably going to be doing, I'm putting you on the spot. So if you have like other obligations, I'm just volunteering you for this if you're not already planning. I'm assuming you're going to be doing the Zachariah Anderson panel on Hella's channel, Excited Utterance, you guys. We'll get the links to that. This is set to redirect over there even though it's tomorrow. That way you guys can hit the notification button. Zachariah Anderson seems like an actual innocence wrongful conviction case. If you guys don't know that story, it's been about 1.5 years since the conviction came down in that case. But seriously, no better crew than going over to Excited Utterance, the panel she's going to have with the background on that case. In addition to Dolly, Excited Utterance, I'm sure you guys know the name Nick Starro. Nick Starro also followed that trial. MLS Law, lots of familiar faces there. So that's going to be a really, really good stream tomorrow. Also, big shout out. We've got all this talk about cases. We have Happily Angry Lawyer in the building. You guys know who he is. Cat's a bit out the bag. So a separate but adjacent case, if you're following the Mungtung saga, Antonio Sledge, we got the case of Darren Mills. Darren Mills is the nephew of Denise Bell. Denise Bell is the 1428 Adele Drive shooting, the drive-by shooting that was mentioned in the YSL trial. Denise Bell was the woman who was upstairs and was shot, and Adrian Love was asking her about the vodka she keeps on the nightstand, the important questions. He had a trial, he had a conviction, and he just won a reversal. So Kyle Winchester was the attorney for the appeal. I think Brian Steele was the attorney for one of his co-defendants at trial. Katez White. I think we've actually joked that perhaps that's where the Quez nickname came from. But his AKA name is actually Spaz. There are some crazy things in Darren Mills' case. One of the most astounding to me is it took the guy years to get copies of his trial transcripts to fight for his appeal. And, maybe if someone's appeal is denied, that doesn't seem like the biggest deal. I say it is. But when someone actually successfully argues an appeal, and they were blocked from being able to make these arguments for years because they weren't able to obtain trial transcripts while they're in custody, that's just a huge issue. So you guys know Happily Angry Lawyer, who is now Angrily Angry Lawyer on Twitter, has been covering Moonktünk, is still fighting for Moonktünk. He recently did a stream on that. Make sure you check it out. He said after the appeal was done, he would do a stream on Darren Mills. So I think there's two streams, one already done and one coming up from Happily Angry Lawyer. You guys need to make sure you check out. Chad Diggy, long time no see. Flesh of the Gods, good to see you. The whole gang is here. Trey Keisha, I've seen you over in Karen Reed trials, but good to see you here. Good to see Mary W. Destined to be, same thing, seeing you over in some Karen Reed watches. YSL Kells, yes, keep the YSL going. Tack Clouds, Zandara, good to see everybody. And Factual Lie, good to see Factual Lie. So let's get into this here, you guys. Let me make this bigger. That barely made it bigger. So let me expand this. And I've learned my streaming thing a little bit. If you want to see some struggle streaming, you can definitely catch that over with Happily Angry Lawyer. This was filed on the 20th. I saw it come through on the docket yesterday. Defendant's reply to the state's response in opposition to the defendant's amended motion to disqualify. So again, earlier this month on like May 2nd, 3rd, Clenney filed motion to disqualify the state attorney's office. Last week, I think on the 16th, state responded, and now this is their reply, the defendant's reply to their response. So comes now the defendant, Courtney Clenney, by and through undersigned counsels, and respectfully files her reply to the state's response in opposition to the defendant's amended motion to disqualify the state attorney's office in and for Miami-Dade from prosecuting the above referenced case. And in support, here's what we're going to argue. The state in their response misstates, so we're getting right into it. The state is misstating. And I love carefully chosen words. This is intentional. To this court, the applicable law in this matter and glosses over the substantial misconduct that has occurred in this case as delineated in the amended motion to disqualify. So right here, plain as day, they're saying, look, we made the argument it would cause prejudice to our client, which is one avenue. And we also made the other argument that the prosecution engaged in substantial misconduct. That's the other avenue we're taking for this motion to disqualify. Here, they're saying, hey, court, they glossed right over it completely. So here's some applicable law. To disqualify the state attorney's office, a defendant must show, in bold, substantial misconduct or actual prejudice. That's from Farina v. State, a Florida case from 1996, holding actual prejudice not shown where state attorney improperly asked clerk's office to assign case to our particular division. Receded from other grounds by Frankie v. State. So something else was challenged in that case, but not this finding. They also cite State v. Clausel. Actual prejudice is something more than the mere appearance of impropriety from Kearse v. State. So a bunch of little cases here that cite each other, all stacking up to support this idea that two avenues to disqualify, actual prejudice or substantial misconduct, are two avenues we've got. Yes, this is Happily Angry Lawyer, if you guys are listening, just said, what a mouthful. Every time I read one of those, that footnote is in the back of my mind. Do I have it here? Yeah, we've got it. Good old Doug. In the back of my mind every time I read one of those. Downs v. Moore, so they cite another case there. This is where this paragraph is coming from. As stated in the amended motion to disqualify, the defendant is moving to disqualify the Miami State Attorney's Office on the grounds of substantial misconduct or, and if you're not looking at the screen, it's big, capitalized, and bold, the word or. And, happily angry lawyer with his red pen. I think a lot of us in the chat, I love a good shall versus may, and versus or. Taco versus sandwich, like all the different nuanced ways that a similar or opposite word, one little word swap can change the meaning. So we've got or emphasized here. So substantial misconduct or actual prejudice, which are the two avenues stated in the Supreme Court's decision in Downs for disqualification of the prosecutor's office. The state has only argued that there is no actual or future prejudice to Ms. Clenney. Understandably, they have not addressed the substantial misconduct of their office. Understandably, I love that energy. And let me reiterate, I started off this case and I still have my gripes here and there. I've got a clip we'll watch. It'll exemplify it a little bit. Clenney's attorneys, when this case first came out, I get that they have to defend their client. Their client was a public figure with millions of followers on OnlyFans, Instagram, I guess OnlyFans you could say is kind of behind a wall, like a paywall. But she still had 2 million followers on Instagram. So to me, clear as day, she's a public figure. They were doing their press tour to defend the public image of their client in public, which I have no gripe with. But some of the way that they did it, it just came off as a little bit inauthentic, a little bit like they were reaching too much. So I have my little pet peeves with their delivery in those early interviews. But here, after all of the state attorney's office has done, a judge has already found that they violated attorney-client privilege. They couldn't convince the judge that there was some crime fraud exception that they couldn't explicitly state. The state really doesn't seem like they want to address the misconduct in their office. So I agree. And I enjoy that they are writing it this way. The state's response attempts to discuss what they have accomplished since the invasion of the defense camp. So paint the picture. Although the state's attempt to put the toothpaste back in the tube addresses some of the concerns of the defendant, the state's response fails to address or defend the substantial misconduct. Specifically, in defendant's amended motion to disqualify that delineates the misconduct of ASA Khalil Quinan, it is important to note that the entire prosecution team adopted and participated in hearings over the last year and or stood by silently adopting the many shifting positions throughout litigation of this issue. Now, this was important, and when we read through that, we saw them argue this. They gave specific examples of Shawn Abuhoff and I can't remember the other prosecutor's name. Kathleen Haig, maybe. They were arguing at the same hearing that Khalil Quinan was defending, peeking in through records he shouldn't have been looking through. They made arguments in defense of it as well. So the defense made this argument in their initial motion to disqualify. They're moving as a unit. They're adopting each other's arguments. And there's an argument here that I think is just cool in general. They cite here from Nespler v. State, there is, quote, a distinction between private law firms and government prosecutorial offices. So there's a difference in how the criteria, the standards, what we would expect of a private law firm versus the government prosecutorial offices. And I don't take stuff like this lightly. They put a footnote here, but I didn't see one. So just so you guys know, I'm not like trying to skip this footnote here. I don't know if this is part of the text in the case itself and they just left the footnote denoted. So we're skipping that. State v. Fitzpatrick. As a result of the distinction, the Florida Supreme Court has recited that imputed disqualification of the entire state attorney's office is unnecessary when the record establishes that the disqualified attorney has neither. So this is why it wouldn't be the case to disqualify the whole thing. if Khalil Quinan, for example, swap his name in here, has neither provided prejudicial information relating to the pending criminal charge, nor, so can't do even one of these, has personally assisted in any capacity in the prosecution of the charge. So they argued in their initial motion that Khalil Quinan had done both of these things. You know, there were over 60 names. I think they said 62 names on the list of people that had access and may have been on dissemination of information. So they're asked in the motion to disqualify, you know, we can either assume that people besides Khalil Quinan had access to this prejudicial information, or the court needs to allow us to speak with all 60 of these people, which just becomes a matter of impracticality. So one problem there, and again, their argument in this reply is that the state isn't even arguing, defending against this issue. They haven't addressed it. And let's see, big thank you here. I see Trakeisha says, I'm so excited for a cat live. It's good to be back on screen. It's good to see you, Trakeisha. Thank you for, you're a member for 9 months. That's super, super awesome. Thank you for being a member for 9 months. Speaking of 9 months and more green, hold on, wait. Do we need an appearance here? We've got Flesh of the Gods on screen doing a, since we can't see, StreamYard doesn't let me pull up the emojis in the chat. It just like shows the little bushes as the title. We'll make it work. We'll put up this bush image. Familiar face, Marissa Viverito. I'm sure all of you remember her. Big shout out also to Chad Diggy, says tap that like button. That is right. That is right. We need a new, I think, what are they? House long to top the like button is some I'm seeing for Karen Reed. We need a new saying. Dolly Talk is winning the race, member for 11 months. Thanks so much, Dolly. How dare they violate Courtney's privacy? If you guys didn't see, and I didn't actually hear this either until Dolly posted it. So Hannah Gutierrez Reed, Rush trial, she was convicted. She was released yesterday. I think yesterday. Maybe it was Thursday. But that was, I don't know if I'm just bad at keeping track of time or if her sentence was way shorter than I conceptualized. Because was that the full 18 months? Like, I don't even know. My grasp on time is just ridiculous. But thank you for sharing that yesterday, Dolly. I got to sit there and like, how are we in May of 2025? About to be in June. Hannah Gutierrez is free just in time for the Rust premiere. Barbara Open Hope, one of my favorites, don't get to see you much, says misconduct from a Florida DA office. Oh my stars. Oh my stars. Speaking of Florida crossovers, Atlanta, we've got a lot of shenanigans in Atlanta. If you guys saw recently, Rod Wave turned himself in. He's faced, I think it's like 14 charges, conspiracy to commit a felony for an apparent robbery at his Milton, Georgia home. That's Fulton County. Lots of stuff going on there. He had a prior arrest that, no, I don't think a conviction came from it at all. I don't even know if it went to forward as a case. But police arrested Rod Wave for felon in possession of ammunition, even though he had no felony. He had no felony record. So, little, similarity there between what Fulton County seems to do and Florida shenanigans. There's no shortage of it. There's no shortage. Let's see. Happily Angry Lawyer remembers Viverito very, very well. And Dolly says 15 months. So there we go. 15 months and had to serve almost all of it. Yeah, destined to be, it just seems super quick to me. And, I'm sure that's good for her, but for me, it just blows my mind that it's even been more than a year. So, also, you guys, shout out to Chad Diggy in the chat here. Chad Diggy is dropping links. Chat, see you all over. Big thank you for supporting all of the creators out there, especially when you're over in Flesh of the Gods chat. Yeah, Happily Angry Lawyer says 1611 131. And if you didn't follow, there's the Tennessee case against Shawn Williams, Johnson City kerfuffle. They were reluctant to give Kateri Dahl, AUSA, she wanted to take a warrant out on a Robert Vo. He was under a pseudonym at first. They were investigating a chain of serial rapes in Johnson City area, Tennessee. She wanted to get this search warrant out to go look at this guy. She thought there was enough stuff identifying him. There was like a bank incident where he walked in and someone identified him as being the same Robert Vo. And her superiors were like not with it, and they ended up firing her. So she had a retaliation suit. I think it's still open against Johnson City. They finally give her a very narrow search warrant for felon in possession of ammunition. And he actually had a felony, so it wasn't like the wrong thing. They botched the execution of the search warrant. They went and like stood at his penthouse door. For 45 minutes, they stood outside the door, and he just went out the fire escape. So even when they actually get you know what? We'll actually appropriately use felon in possession of ammunition or whatever to execute an arrest warrant on somebody. They just stood outside his door and didn't really try. Like, it's just crazy. It's just crazy when you think at the big picture of the way things go wrong. So let's see what else the Clenney team is arguing went wrong. Here, ASA Quinan provided prejudicial information relating to the pending criminal charge. So, again, the language here, Quinan is personally assisted in any capacity in the prosecution of the charges. So right there, he's providing prejudicial information relating to the pending criminal charge. That's participation. And he personally assisted in the prosecution for over a year after having violated the attorney-client and work product privilege. As such, recusal of the entire state attorney's office is warranted because it's undisputed that the disqualified, by choice, assistant state attorney in this matter, Khalil Quinan, personally assisted in the prosecution of the charge. Not disqualifying the entire state attorney's office under these circumstances is repugnant to the administration of justice and creates a well-founded fear that the confidential communications between Ms. Clenney and her attorneys will continue to be violated. As stated by the Florida Supreme Court, quote, when defendants no longer have absolute faith that all confidential communication with counsel will remain forever inviolate, no candid communication will transpire, and the guarantee of effective assistance of counsel will become meaningless. This is too high a cost for society to bear. And this is from Castro v. State, which also quotes State v. Fitzpatrick. This is actually a dissenting opinion there that was used. So the State v. Fitzpatrick is from a dissenting opinion that was later used in Castro v. State. And this is the chilling effect kind of argument, right? To the extent that this chilling effect would end up depriving someone of their constitutional right to defend themselves. So the state argues that the matter before this court is more similar to Nunez v. State. That's a district court of appeals. However, unlike Nunez, disqualifying one state attorney that overheard a conversation between the defendant and his counsel, the entire prosecution team has been consulted on the invasion of the attorney-client and work product privilege. Right? So there's a little bit of a distinction there. So I would love to get this full response from the state and read it in full. But it seems like they're citing this case where the situation is somebody overheard, meaning likely not intentional. Passerby happened to hear this information. And maybe that attorney said, guys, I overheard this and I probably shouldn't have heard it. I don't know the facts of this case. But that doesn't seem to be the same as somebody going through a bunch of group chat communications with attorneys and parties that were family members discussing things in furtherance of the defense of Courtney Clenney, and were also clients themselves of that same law firm. Seems a little different. Seems a little bit different. The entire team and many others, known and unknown, were consulted on the issue of attorney-client communications from the team Courtney chat, and then the entire prosecution team actively participated in litigation concerning the clearly privileged email that laid out the entire defense strategy. This matter is more akin to State v. Martinez, where the trial court disqualified the entire state attorney's office after several attorneys listened to jail calls between the defendant and counsel. So what do you think? Do you think going through group chat conversations, and I think a lot of you in the chat, were here when we looked at the arrest warrant affidavits for the parents relating to this laptop thing. Do you think the laptop and the group chat, and then in addition, some of the emails, like the list of Courtney Clenney's defense strategy that said confidential or whatever, do you think that leans closer to someone overhearing something in a hallway or closer to someone listening into a phone, like an audio conversation? I'm going to say it leans more this way. Just me. The calls in Martinez discuss inter alia, the testimony of witnesses, counsel strategy, and other issues regarding trial planning. These are exactly the areas and contents contained in the privileged document that was reviewed by Mr. Quinan and law enforcement at minimum. And remember, it was two law enforcement officers that the defense actually got acknowledgement that they themselves were aware of some of these contents, and that Quinan was just kind of like, yeah, go ahead and look at it. I looked through it. It's fine. You don't need to filter it. So these two law enforcement individuals being mentioned are a big reason why we were able to figure this out. The trial court concluded that the lesser sanction of disqualification of the individual prosecutor would not suffice because the recordings were heard by a number of attorneys and the contents were discussed throughout the state's attorney's office, distinguishing this case from Nunez v. State. So actually pretty interesting here is that the case they're citing is making the same distinction. So that seems pretty compelling to me. Consequently, the disqualification of the entire Miami-Dade State Attorney's Office is warranted to provide a fair and impartial trial for Courtney Clenney and protect the integrity of the judicial system. So, and, I think this is, Dolly Talk says, parents never should have been represented by the same law firm, LOL. And, my opinion on that is if it's a conflict of interest, that's got to be taken up with the court. Can it be waived? Is there an issue? But as far as there being an agreement and an expectation of confidentiality, because remember, there's two layers. Was that attorney-client privilege because of a direct attorney-client relationship between law firm and Kim Clenney and or law firm and Deborah Clenney? But it also could have been protected conversation if there was an expectation of privacy in that group. There were no public outside members part of that conversation. It was just the law firm parties and the parents. And they were discussing things that were in furtherance of the defense of Courtney Clenney. So they had actually made those two arguments to Judge Laura Sharon Cruz. And the issue was the state was like, sure, but there's an exception either way because we think there's crime and fraud going on, and there's an exception to that, Your Honor. And she's like, okay, well, where's the crime fraud? Where's your evidence of some type of nefarious activity going on there, some type of cover-up scheme? And they couldn't convince the judge. I think their angle was they were trying together to get into this laptop and maybe delete information, and they just couldn't prove it. They couldn't find anything to substantiate that. So if you ask me back then, that might have been a little disappointing to me, but now I just feel like it's a prosecutor playing dirty, looking for things that he didn't need to win his case. And we're going to go back and we're going to look at the sentiments a year ago before all of the stuff with the laptop and the parents' arrest even came into the picture. We're going to look at some sentiments. And, if we were to pull a mock jury pool out of the people that we're seeing the sentiments from, the prosecution didn't need to do all this just to try to be a means to an end to win their prosecution at any and all costs. Without any of this taking place over the last year and a half, I think they would have had no problem winning a conviction against Courtney Clenney. So I think all of this is just completely unnecessary for the prosecution to do. So, good to see you, Kate. Good to see you. I think I've seen you bouncing around. I think it's been in Karen Reed chat. So good to see you here. So let's see. Conclusion. The actions taken by the state are precisely the type of substantial misconduct that warrants disqualification of the entire state attorney's office, as discussed in Martinez. This is actual prejudice as delineated in the amended motion to disqualify. Furthermore, actions taken by the state in reviewing privileged materials rise to the level of substantial misconduct. Under the analysis as discussed in Downs, Ms. Clenney must show either substantial misconduct or actual prejudice. So, or. Disqualification of the entire state attorney's office is appropriate as there has been substantial misconduct on the part of the state and or actual prejudice flowing from that substantial misconduct. So this is sent in on the 20th. We've got Frank Prieto, Sabrina Puglisi, and Diana Karamis. So there you go. That's their reply. Judge said at the status thing that they had on the 22nd, look, we'll get a decision on this on the 25th of June. So we've got a month to go. But I think it's just, how are we here? Why are we here? It's just stupid. And I know that Clenney's team did motion for a reconsideration of bond. It was denied. But if you think about it, the reason this is taking so long to go to trial, whether this delay benefits the defense or not, this delay, 1,000% in my opinion, is the fault of the prosecution's office. That's why we're here. Trying to prosecute the parents for the laptop and then all of this because of the attorney-client privilege, that all stems from actions of the prosecution. So why are we here? They would have been better off, and I'm so confident in it. If this had gone to trial already, I think they would have had their conviction. If we just skipped all of the laptop stuff, I think they would have had their conviction. I think they would have had their conviction in 2024. And we just didn't get there. It's just ludicrous. So what I thought would be really cool to do, take a look back at the initial affidavit. We're going to go back to 2022. This is like 6 pages, I think. We're going to look at the attorney's initial response after Courtney was released, again, back in 2022. And then we're going to look at some sentiments in some comments on like viral videos about the case from before this laptop stuff happened. Because I'm telling you, the sentiments, if you pulled a jury pool, I think, unless you ended up having that one person that just was a holdout for the sake of it, and, you know, not to shout out to the holdouts that stand their ground and believe in what they believe in, right? That's not really what I'm trying to say. But I really think the odds of picking a jury that would convict Courtney Clenney based on what's available were really high. So I just don't get it. So since it's been a while, this was the affidavit from Miguel Delau, or that's the judge who signed it. This all the way back in 2022. This is the version of events that we were working with. And to be honest, certain facts have changed or not really come forward, but the rundown of the story is pretty much the same, right? They're in the penthouse. Knife is thrown from allegedly 10 feet away. That's it. There's no other multiple stabbings. It's just this one throwing of a knife. There's some 911 calls and calls to Courtney Clenney's mom. Some neighbors saying that they've heard fights before. That stuff hasn't changed all that much. So here we go. Why do we have probable cause to arrest? Let's see. Courtney Taylor Clenney, here and after the defendant, a white female with a date of birth of whatever, 1996. A social security, they blur all this out. For one count of murder in the second degree of Christian Obumseli with a weapon, to wit, a knife. A life felony in violation of Florida statute. 78204, section 2. Your affiant, Detective Jermaine Berseno. I'm forgetting how to say his name. I don't think it's Berseno. Is a detective in Miami-Dade's police homicide unit. Your affiant has almost 5 years of experience as a detective with prior experience in MPD's robbery unit. Your affiant specializes in the investigation of murders, attempted murders, robberies, false imprisonment, and kidnappings. Your affiant was assigned as the lead investigator in the April 3rd, 2022 murder of Christian Obumseli, documented under case number, we're just going to say 3743. I'm actually surprised this is cool. They actually made this highlightable and searchable. Facts in support of the probable cause. This affidavit is being submitted for the limited purpose of establishing probable cause, and therefore does not include every aspect, fact, or detail surrounding this investigation. The initial police response. I've got, if you haven't seen them, they get a little graphic, you guys. I blurred out one part because it's like genitals. But I didn't like trim out parts with blood. They are pretty graphic, so just a forewarning. If you want to look at the body cam, there's 3 different body cam, like first responders to the scene up on my channel. And everything, it like shows their response, shows their struggle with trying to use an elevator or a staircase. It's ridiculous. How they treated Christian Obumseli. They handcuffed him while he was losing consciousness. Flipped his body over while he's bleeding out from the chest to handcuff him. So it's not light watching. And then, of course, there's the conversations with Courtney Clenney captured over the next hour and change between her and the initial first responders and the officers that were on scene. So really some insightful, crazy stuff in there. But they've got all this, they had all this information at the time of this affidavit. So they responded to this unit at 1 Paracio regarding a male suffering an apparent stab wound on April 3rd, 2022. Upon arrival, officers located the defendant cradling the body of the victim with an apparent stab wound to the chest. The defendant was taken into custody, and officers rendered aid to the victim until fire rescue arrived. Which kind of, they handcuffed this guy, and then like a minute later, like the EMT team shows up, and the lead person on that team is like, why is he handcuffed? Can you get the cuffs off of him? So if it was just like a 1-minute difference, I mean, maybe it could have made a difference. The victim was transported to Jackson Memorial Hospital, Ryder Trauma Center, where he succumbed to his injuries and was pronounced deceased by Dr. Mezoso. The defendant was taken to MPD headquarters, where, post-Miranda, she provided an audio and video recorded statement. Following the defendant's statement, this is where we have the flinging language. This is where she says she, like, flung the knife. She was released pending further investigation and consultation with the state attorney's office. So remember, this is April. She's not arrested until August. The investigation. The victim's body was transported to Miami-Dade County Medical Examiner's Department. An autopsy was performed by Chief Medical Examiner Kenneth Hutchins. Hutchins determined that the cause of death was a stab wound to the chest, and the manner of death was homicide. Specifically, he found that the victim was stabbed, and that the knife punctured the subclavian artery in his right chest. The knife entered in a downward angle to the depth of 8 centimeters. They're using metrics, you guys. Following the medical examiner's findings, MPD presented and consulted with the state attorney's office regarding the initial facts. As a result, various investigative steps were taken by the MPD and the state attorney's office, including several warrants and subpoenas. Additionally, information was received from other out-of-state law enforcement agencies. So, they've got incidents in Las Vegas. They have an incident from Austin that we've looked at. But they're saying here, look, there's some type of background here, not just of Courtney Clenney, but there's actually been previous like police calls in relation to Christian Obumseli and Courtney Clenney having fights or altercations from other areas. Accordingly, evidence obtained showed the defendant and victim had a tempestuous relationship since November of 2020, with multiple incidents of domestic violence from both sides over the period of their relationship. 1 Paracio security and building staff documented so many incidents of arguing, which is just weird language. So many incidents of arguing, including complaints from tenants as far as 2 floors above the defendant and victim's unit. That 1 Paracio management was moving toward legal action to evict the defendant and victim from the condominium. Now, this might not seem significant. I think it's weird that they're so vague. Like, so many is crazy to write in an affidavit, but whatever. This note about tenants 2 floors above being able to hear was a pretty important point of contention. There was a October or November hearing to suppress some recordings, like phone recordings, audio recordings that would have been recorded in their apartment building at One Paraiso. And the state argued there's no expectation of privacy if people are saying they were 2 stories away and were still able to overhear this. And the defense responded, well, they might have been able to hear commotion, but they wouldn't have been able to hear the words. So Judge Laura Sharon Cruz did end up allowing certain things to come in. I think namely when they had a witness saying they heard specific words for a specific time period. But other things, certain surreptitious recordings just can't come in. Because if we don't have a witness saying they were able to hear that particular point in time from a building away, from a story away, there was an expectation of privacy. It was a surreptitious recording. So that was actually a pretty contentious thing right here. And again, those evidentiary rulings are like 2 years ago at this point. And then the One Paraiso management moving towards eviction. There's been a whole bunch of back and forth there too. An attorney that works with the Haggard law firm that's representing Christian Obumseli's estate did an interview with Peter Tragos on The Lawyer You Know. And in my opinion, that attorney overstated something, because we ended up getting a copy of this email later on after she did this interview. She represented it as if Courtney Clenney was bribing and there was something inappropriate going on between One Paraiso and Courtney Clenney to cover up the physical behavior that was apparently the cause of the eviction. In the email, it was a monetary thing. And Clenney's like, look, I've been having some issues, but I'm getting my life together. I am getting treatment for my mental health, but I'm going to catch up on rent. I'm going to pay you next month. I'm going to get you everything. So there's a lot of mismanagement in the public realm, the coverage of the case regarding this cause of eviction, right? And that's coming from the attorneys for the estate. It's not really coming from the prosecution's office. So defense can't point the finger and blame the prosecutors for extrajudicial statements when it's coming from private attorneys. So a lot of mess there. While certainly not one-sided, the evidence shows that there were prior incidents of the defendant being physically violent with the victim. For example, in July 2021, the defendant was arrested in Las Vegas for domestic battery on the victim in their hotel. And that was a hot mess. Go look at that Vegas footage. The room is destroyed. Just a mess. Similarly, surveillance from One Paraiso showed an incident in February of 2022 where the defendant aggressively attacked the victim in the elevator. The defendant and victim moved into the apartment in One Paraiso in January 2022. So, this made it just over 3 months with this move-in together in Miami. Almost immediately, incidents of violence and arguments began with One Paraiso security and building staff documenting many incidents. This tumult also caused the defendant and victim to separate various times, including the last week of March 2022, when the defendant expelled the victim from their collective apartment while the defendant's mother was in town. After the defendant's mother left to go home to Texas, the defendant and victim rekindled their relationship on Friday, April 1st, 2022. The victim moved back into the apartment at that time. Arguments began almost immediately, with police responding and contacting the defendant, who appeared intoxicated when she made the report on the evening April 1st, 2022. Now, this is that infamous lobby video. At first, only a few clips were released. And she was like, I want a restraining order. And she's tapping her nails together. She's like, I want a restraining order. And she mentions calling her attorney, but it's really her dad. And there was a 1-minute clip that was released. There's 3 different angles up on this channel if you want to go and watch those in full. But it's really interesting because in that clip, she's like, I haven't always been the victim, but I'm the victim this time, which could be helpful to her. She's asking for a restraining order. But then there's video footage of them hanging out and having a good time between April 1st 2nd, 3rd. He comes back from somewhere. He gets the dogs, goes back to walk the dogs. He comes back up the hotel elevator. And then minutes later is when the stabbing occurs. So this is one of those things where it really comes down to, what is a jury going to look at? What is a jury going to think? Evidence shows that Sunday, April 3rd, began peacefully with the defendant and victim playing with their dogs in the apartment. At some point, the victim left their apartment and returned with Subway sandwiches for himself and the defendant. The key fob records show that the victim left the apartment at 1:15 and returned at 4:32 p.m. Surveillance shows that the victim returned to their apartment at that time via service elevator 1 with their 2 dogs and actually leaving the elevator at 4:33. At the same time, the defendant finished and uploaded an Instagram live video to her page. Call detail records show that the defendant called the victim at 4:01 p.m. just before she went live on Instagram and again at 4:33, shortly after posting the live video and his arrival to the apartment. Now, what's interesting, and I never caught this until now rereading this, but they make this seem like one trip. But when you look at the elevator surveillance footage, he's gone for this like 3-hour block of time, comes back upstairs, and then he's going back down the elevator again with the dogs. So then he comes back up. So there's like a 15-minute goes back outside type thing. Let's see. Based on phone records and testimony from the defendant's mother, Deborah Clenney, hereinafter D. Clenney, via a recorded telephone call with the police, a time frame for when the stabbing occurred was able to be determined. In that recorded call, Deborah Clenney confirmed she was on the phone with the defendant via 2 phone calls that started at 4:43. So that's how narrow this time window is. You know, leaving the elevator, because the elevator goes right up to their penthouse. It's like a private entryway. So 4:33, 4:43, 10 minutes, and continued until 4:56 p.m. Deborah Clenney further confirmed she was on the phone with the defendant at the time of the incident. Thus, the stabbing must have occurred between 4:43, fewer than 10 minutes after the victim returned to the apartment, and 4:57, when the defendant called 911. The defendant's call detail record shows the aforementioned calls, reflecting the defendant called Clenney at 4:43 for a call that lasted just over 6 minutes until 4:49, and a second call at 4:49 for a little over 7 minutes until 4:56. Accordingly, the evidence establishes that the stabbing must have occurred in the intervening 13 minutes. So just like, they don't have camera footage of inside this exact 13 minutes, but you've got footage of Courtney Clenney hitting him in the elevator. We've got text messages from this week, or notes, I should say notes. It's not text messages, it's notes that Courtney put in her notes app in her iPhone, where she's describing thinking she's losing Christian Novomseli and the tension in the relationship for other reasons. Me, 10 minutes, seems like as soon as someone walked through that door, an argument kicked off. Typically, the one who's out of the house is who I would imagine the person in the house is feeling some type of way about. So I don't know. Kate, I heard that too. She was drunk or acting like it on that Instagram live right before he got back too, right? Yeah, and there's still footage of that. I don't think I've ever played it on a stream. I think she's wearing like a black bra and her hair's down. So if you guys like go looking for Courtney Clenney footage and you see that look, that's the video. And it's like one of those tall Instagram live videos. But yeah, she was like talking about being annoyed and a bunch of stuff on that live. Yeah, for always, forever, for life says the fact that they took months to arrest her, egregious. What happened to probable cause? I'm disgusted. And I do truly believe that social media put pressure on this office to take some type of action. And sure, they could say that they were investigating it this whole time, but... Touche, good to see you. Touche says, hello, everyone. FFS, are you just... The Haggard law firm got you going over here? But yeah. Let's see. So, what do we got? At the same time that the defendant's calling mom, the neighbors are calling One Paracio to report a disturbance at the apartment. One Paracio's security called 911 at 4:46, notifying them of the disturbance. 11 minutes later, at 4:57, the defendant called 911 to inform the police the victim was suffering from a stab wound and requesting help. So here you go. You've got a 911 call made by the desk. So for One Paracio to make a 911 call because they're getting a call from residents, like that has to happen, and they're still getting this done by 4:46. But Clenney herself doesn't make this 911 call until 4:57. And this is that call where she's distressed and she's like freaking out that he's bleeding and she's worried that he's gonna die. But maybe you should have been that worried 10 minutes previously. So, inform the police that the victim was suffering from a stab wound and requesting help. On that call, the victim can be heard in the background repeatedly saying he's dying and cannot feel his arm. The defendant is also heard saying, "I'm so sorry, baby." In her telephone recorded statement to the police on the date of the incident, Deborah Clenney, mom, stated she heard the defendant yelling at the victim to leave the apartment and that the defendant saying the victim was, quote, lying. So this is going down. Courtney's on phone with mom and Courtney's yelling off about how Christian's lying. Christian's lying. You're lying. I've been in situations where people have accused each other. A person that's like, "You're lying to me," is usually the one that seems to be the aggressive one. So that's an important detail right there, and that detail's coming from mom. In her explanation to the police regarding the content of the phone calls of that day, Deborah Clenney did not say she discussed the incident with the defendant. However, investigators know Deborah Clenney did communicate with the defendant about the incident because investigators saw a text message from mom on the defendant's phone recorded at 5:25 p.m. that mentioned self-defense and advised her not to say anything to investigators without an attorney. So, I mean, good advice here. But, you know, if this was worded in a way, and I'm not sure if this full... I think we get some context on this in the bond hearing, which we can rewatch. We'll do a stream. I keep saying I'm going to do a bond rewatch when the trial's about to start as like a refresher. And I don't know when that's going to happen. But if the message is like, "Oh, you'll be fine, just say it was self-defense," versus, "What? Don't even worry. You had to defend yourself. But still, just be careful. Don't say anything without an attorney." Like those two types of context have different meaning and different ways to read between the lines. So, you know, is this like some type of consciousness of your daughter's guilt that isn't justifiable and you're just telling her to say the magic words? Or are you giving good advice, authentic good advice? Because either way, whether you're guilty or not, I still think good advice here not to say anything to investigators without an attorney. In addition to omitting her conversations with the defendant, Deborah Clenney's recorded statement also omits any claim that the defendant said she was being attacked by the victim during the call. So there's your problem. You say all of this in a text message. It doesn't really seem to jive. So maybe you should have just said this part. "Hey, we're on our way. Don't say anything without an attorney." Although the defendant admitted to having caused the victim's injury in her post-Miranda recorded statement, she also provided several inconsistent accounts of the incident. The defendant claimed she armed herself with a knife in response to the victim having shoved her against the wall by her neck, though not choking her. And then she claimed he threw her to the ground, but then allowed her to get up. The defendant's physical body was documented on the date of the incident, and there were no injuries to her person to corroborate this account. At no time did the defendant claim the victim was armed with any type of weapon. In describing the stabbing incident, the defendant claimed she threw the knife at the victim from a distance in excess of 10 feet. Based on the location and depth of the stab wound, the medical examiner opined that throwing the knife from that distance would not have caused that fatal stab wound. In trying to explain her actions that day to the police, the defendant stated, "I do not think..." This is Courtney Clenney to the police. If you haven't seen her interrogation interview video, This is Clenney. I do not think this was, I don't know, I really don't know if this was justified at all. And then the crime scene. So, well, if anyone's queasy, before we get away from why the medical examiner is saying he doesn't think that this type of stab wound could have been caused by the mechanism claimed, from a distance, he thinks it was a downward movement, which suggests up close with force rather than impact from a perfectly landed place knife throwing one time. I'm going to pull the exhibit of the knife at the crime scene. So if you don't want to look at the screen, this is like this is the time to look away, guys. But 5, 4, 3, 2, 1. And we have, this is the knife that was used. That again, Courtney Clenney is saying that she threw from 10 feet away, pierced him in his subclavian artery, and was like 8 centimeters depth was the stab wound. So, and the screen is back to clear. So if you want to look back at the screen, we're back on text. Now the crime scene. So the condominium is a 3-bedroom, 3-bathroom unit with a private foyer. Again, these body cam videos will give you a good view of the layout and how everything was happening. But this part here, so they have, when you actually look at the body cam video, he's in the kitchen area, and it's one of those open style kitchens where there's like a den, like living room area. It's like an open format, and then there's a door to the left, a locking door, and a master bedroom. And this is apparently where Courtney Clenney would have been standing when she was 10 feet away, but still felt like she needed to throw the knife rather than just go and close the door. So that's some important context, in my opinion, about the shape of the apartment and the events as claimed by Courtney Clenney. The physical crime scene showed droplets of blood by the kitchen island dripping to the master bedroom / bathroom and back into the living room. In the living room by the couch, a bloody knife along with a bloody bedsheet was located. There was additionally a blood trail leading from the living room to the guest bedroom. At the entrance of the guest bedroom, there was a puddle of coagulated blood and blood transfer on the wall, evidencing that the victim collapsed in his room before attempting to return towards the front door. Upon police arrival, the victim was in the defendant's arms at the intersection of the 2 guest bedrooms in another puddle of coagulated blood. The amount of blood through the condominium at different levels, including 2 large pools, evidences that the victim was bleeding for an extended period before police arrived. So, again, like, he died because of this blood loss. Could a 10-minute earlier call have saved him? If the building didn't have issues with their elevators and staircases, that's obviously a contributor to the time of response as well, right? But the initial call to get medical attention, and then the ability for the first responders, the emergency medical team, to actually get up and start treating the victim. Like, these 2 things, I really wonder if this 10 to 20 minute difference could have saved this guy's life. In addition to not flipping the man over while he's bleeding from the chest. To, imagine you're bleeding from your shoulder. I don't really know anatomy that well, but if I'm bleeding from right here and you flip me over and you're pulling my arm behind me, I feel like my blood's got to be coming out stronger. Right? It's just you're pulling my shoulder taut and backwards where there's the open wound in the front. That can't be good for keeping blood in. So all of these things combined, I really don't feel like Christian Obumseli had to die. Anyway, let's see. She's cradling him. They see the bloody knife, similar to the knives on the kitchen counter. And that's just an important mention because it's just kind of like, they're the only 2 in the house and the knife looks like it belonged from this house. It seems probable that someone in the house threw this knife. Was found on the living room floor next to the couch and bloody bedsheet. So in conclusion, the evidence in this case evaluated in its totality reflected the victim and the defendant were in a violent and toxic domestic relationship for over 2 years. The incidents of violence began escalating with the defendant throwing and or using weapons on various occasions. These incidents culminated on April 3rd, 2022, with the defendant acting without justification and causing the death of the victim by stabbing the victim in an imminently dangerous act, demonstrating a depraved mind without regard for human life. So accordingly, the judge signs this, they get the arrest warrant, they ultimately arrest her in August of 2022. This right here, despite the mother's advice, is probably, the most important part of this affidavit, because they have Courtney Clenney's own words saying, I really don't know if this was justified at all. So you have the person who would have firsthand knowledge saying they don't know if it's justified. But still, you have her saying this while she's being interviewed the same day. And they don't move to get this arrest warrant till months later. So after the news of the arrest, a couple days later, on August 11th, 2022, Frank Prieto sends out this press release to a bunch of outlets, and I'm not going to fault them for doing this. You're defending your client. I have no problem with that. But back then, I was just icked out by the way these attorneys spoke in the media, the words that they used. And now I'm so disappointed in the state attorney's office that maybe I'll read this differently. I haven't looked at it in years, but let's see what it says. It is a shame that the state attorney's office is seeking to win this case in the court of public opinion by showing an irrelevant and likely inadmissible video of Courtney in an elevator getting physical with Obumseli. The video does not depict the events leading up to what was captured in the elevator. Obumseli was the abuser, and the worst kind of abuser. He would manipulate and abuse Courtney in private when he thought nobody was around. Do not forget that the initial investigation from the City of Miami Police Department uncovered an independent witness. So this is Arthur Cupp that they're talking about, but they didn't name it here. Who saw Obumseli hitting Courtney in the head while he thought he was in the privacy of Courtney's apartment. And you notice they keep saying it's Courtney's apartment, it's Courtney's apartment. Nobody has ever denied that Courtney and her abuser had a tumultuous relationship. It is inappropriate for prosecutors to try and taint the community against Courtney to the point she may not be able to receive a fair trial. The charging decision in this matter should have been made on the evidence of what occurred that evening in the apartment and nothing more. This is a case of self-defense, and the facts that will be presented at trial will prove this. Also, the arrest warrant issued in this matter contains deceptive and incomplete statements. Now, you heard me call out some of it was vague, like what does so many mean? I don't really know if deceptive is what I would use. I would just say it was vague, it was incomplete. I personally feel like even now reading this, I feel like the language here is a bit deceptive or corralling, which still, you're the defense attorney. I'll hold you to I think you have looser standards than the government should have, right? And I also think if the government is yelling out to the public that somebody's guilty, the defense attorney should be able to vocally, very loudly, be just as loud in the media. It should never be, the balance should always favor the defendant, in my opinion. But still, some of the wording here bothers me from the defendants. Also, even today. Also, the arrest warrant issued in this matter contains deceptive and incomplete statements, clearly an effort to justify a finding of probable cause when presented to the magistrate. Further, and that I agree. With Happily Angry Lawyer in the chat, I think I've seen this done in much more egregious ways with other probable cause affidavits than I'm seeing with the one that we just read. I don't think that this was like a 5-star affidavit by any means. But was it the most copy and paste and malicious and misleading? Like, did they start going on and on about gang affiliations out of nowhere because a pill was found on the bottom of a car? No. So, but a defense attorney, they're doing what they can at this point in time to make a public defense of their client. So I don't really agree with them, but further, the medical examiner has formulated conclusory opinions that will not stand up to scientific scrutiny. Unfortunately, it appears that the prosecutors have taken the easy way out by charging Courtney. effectively placing the decision to clear Courtney of these charges in the hands of the judge and jury. We are confident she will be exonerated, and Courtney will be seen for what she is. That's a bold way to word this, because you're letting me fill in the blank before I read it. This would not be the blank I would have filled in, personally. A victim of domestic abuse that survived her abuser. So there was his statement on behalf of Courtney Clenney on August 11th, Oh, I'm not on the screen. Sorry, guys. 2022. But yeah. So, interesting to take a look back at now. I love the snarky language from the defense attorneys in the reply to the government. I think the language here was way overreaching on the victim, and there's some things here that, as you're saying, the prosecution, their medical examiner's opinion won't hold up to scientific scrutiny. That wasn't challenged at the bond hearing that happened in November, a couple months after this press statement. And all of this delay in time, I said earlier in the stream, I don't really know if the delay strategically has harmed Clenney. She spent quite a bit of time trying to find a knife throwing expert to do a demonstrative where you can, from 10 feet away, land a knife of that type. They use a similar make and model in that type of position that would land at a downward angle if you threw it the right way. That time was helpful, in my opinion, for them to find this expert witness, this demonstrative. And that pig throwing demonstration, they use like fetal pigs to do the knife throwing demonstration. That demonstrative video is available. Did we watch it, guys? I don't remember if we watched it together, but I know it's on YouTube. I know it's on YouTube. But yeah. Yeah, so Happily Angry Lawyer says, yeah, I agree, there should have been like 3 sentences. I mean, it could have been, the facts at trial will show our client is innocent or justified. And maybe a sentence condemning the prosecution for trying to sway the court of public opinion. Hit those 3 marks and just move it on. Okay, yes, the factual lie, yeah, we did watch it on here. So, and like, that's the thing. I think it's helpful, this time delay, to get these experts together. A few months ago, Courtney filed notice that she was going to rely on a battered spouse defense. So I don't know. If this went to trial in 2023, if that even would have come into play. So I think this time delay, as much as it's draining, I think it's ridiculous. Courtney Clenney is someone that had money from OnlyFans, several million. Her parents seem to be well off, and she put her house up for sale, and I'm guessing because she has to keep paying her legal fees while this is being drawn out. I don't like that this is the way our justice system goes through the motions, right? What about someone that doesn't have millions to keep their defense going, or a house with equity in it that they could use to keep their defense going when it's taking 2-3 years to get a trial date? So I know some people could be like, oh, you're a bad person, so screw your house. But this shouldn't be the case for anybody. So the next thing, last time we got together, I mentioned a different neighbor, and we heard some discussion in this affidavit about like prior incidents of violence. In last stream, I was like, oh, a neighbor that lived downstairs from them in Austin, I forget their name, a tiger painting fell. Well, this is the tiger painting we talked about last. Courtney and Christian were up here. This is not One Paracio. Again, this is where they used to live in Austin before they moved to the Miami penthouse. And this guy, they're fighting upstairs above him, and this tiger painting just like crashes down into his balcony.
We're freaked with Austin.
So there you go. There's some, like, we have the Vegas police stuff as well. But there's where some other police reports that were mentioned in the affidavit, there's an example of that. This on the screen right now is the press conference after Clenney's arrest. So, not every arrest gets a press conference. This one had a press conference, and they did speak. I just gotta laugh at this setup. They made this man The mic is like at his belly button. Back to keep the mic out of the screen, and then they just show the mic on the screen anyway. Oh my goodness. But yeah, there were some other friends. Ashley Vaughn. There's another interview somewhere with like a group of 3 friends that used to hang out with both Christian and Courtney. And in that little clip that they did, they're like, we'd seen her hit him before and we've never seen him hit her. So, you know, there are some, so the defense has this guy, Arthur Cupp, that says, hey, you know, I live a building across the road, but I can see their balcony from my windows. And last weekend, I saw him hitting her and I felt like I should come over and say something to you. And that could be very credible, right? From a distance, he probably saw what he thinks he saw. Whether it was actually, you know, Christian being offensive, or maybe Christian's taller, maybe it was, you know, just the cradling to stop someone else from fighting. You don't really know. To me, it'll be pretty easy for any attorney worth their salt, without having to call Arthur Cupp a liar or say he's doing anything intentionally misleading or malicious. Just be like, you were all the way over there looking through 2 different window panes. They had curtains. You didn't see the beginning. You didn't see the end of it. You can't say for sure whether or not he started with the aggression or she did. No, you can't. He can't make that conclusion. He doesn't know. He didn't see it. Not sure of his own eyes. But you have multiple friends plus video footage of Clenney hitting and swinging on Christian Obumseli. Even the Aspen video, she's swinging with her arms over her shoulders at him, and he does make contact with her, but it's, and I've seen people say, see, he touches her, but he's kind of like holding to her elbow, almost like to hold her arms down to her side so she can't swing. And to me, I'm the type of person, if you keep showing me that same type of, he's the one that's always, and she's the one that's always like this, I'm more inclined to think that that's the dynamic on April 3rd, 2022. So, yeah, FFS said, who set that mic up? That mic is miking. Right, it was like a great position, and then they still zoomed out and gave away the shot. Happily Angry Lawyer says, this dude, I think we're just talking about, how did they say his name? Nizvitsky? Something like that. I have this other video open, and we're not going to play it, but this was from before all the laptop stuff. This is from October 6th, 2023. And I don't know, do you want me to, we'll just, top comments, newest comments, they're all saying a year ago. So I guess some of these comments could be, let's see, let's just go back through some. Yeah, the defense team is disgusting. She stabbed him once already. She isn't a victim. Toxic relationships don't warrant murder. And again, some of these, it's not showing me when they were posted. I need Gaither, I need Sprinkle to tell me how these dates work in these comments. I thought it was very trash talking from her lawyer to say Christian's father raped him at a young age. That was a big issue too. The prosecution office wanted a broad gag order against the defense team. They didn't want them to be able to do any more interviews. And the judge was like, well, how broad's the scope? And they agreed that it could become narrowed. And that one of the examples was Frank Prieto going on an interview and saying that there's evidence that Christian Obumseli was sexually abused as a child by a family member. But it turns out there actually is evidence. It's not compelling evidence, in my opinion, but evidence is just something that could go to prove the truth of something. But there is in Courtney Clenney's own notes app. So it's like hearsay on hearsay. She says she writes a note to herself talking about how Christian told her he was essayed by his father. So she's writing something in a notes app that she says was told to her. That's that one little piece that Frank Prieto was referencing here. So that gag order, they did restrict this one narrow thing, but other than that, the judge was like, no. Like, we're not just restricting everything. Let's see. We've got a white people comment. These white people are unbelievable right now, including Court TV. Court TV has very much been on... they've been a huge platform for the defense attorneys. That's where all of these interviews I'm referencing, I think like 9 out of 10, almost 10 out of 10 interviews that I'm referencing with Frank Prieto or Sabrina Puglisi have been with Julie from Court TV. Yeah, the attorneys have no shame. The apartment was filthy. Courtney's disgusting. Your client is deranged. Are there... Just browsing. Are there comments here that make it seem like the prosecution would have had a hard time convincing 12 people that she's guilty, that she was not justified, that this was not self-defense? This was the sentiment. This is the sentiment in response to a video from a channel that's giving, in my opinion, very defense-friendly information and coverage, especially because they're having the defense team come on so often to speak. And yet the sentiments in the comments are overwhelmingly against Courtney Clenney. And yet the prosecution felt like they needed to do all this stuff. We just need to be a mess for the sake of it. And that's so stupid to me. So that's my diatribe, you guys. I'm going to flip back over to, whenever I have 2 YouTube videos open, it always lags my StreamYard. So I'm going to close that one out. No. Happily Angry Lawyer has new beef with Sprinkle. Do you want to close the chat? When we end this stream, do you want me to play the Sprinkle song? When are you doing a stream next, Happily Angry Lawyer? Let us know. And you don't need to let us know on what. I'll be interested no matter the topic, but if you know what it'll be on, let us know. For Always Forever for Life says, plus what she wrote in her journal about hitting him to let out her aggression. Yeah, and that was, I believe that was like early 2021, right? So they meet in November or fall of 2020. They met at like an OnlyFans party, I think. And then they end up like connecting like a month after that. And whatever, they get close, they start doing what it becomes official enough, right? But in 2021, early 2021, in her journal notes to herself in her phone app, she's saying she needs to stop hitting and throwing things at him to relieve tension. She doesn't say I need to stop throwing things at him and hitting him to defend myself. I should just get away from him. She says I basically just need to stop losing my temper and taking it out on him physically, just because I'm angry. And then we have this affidavit that says, Mom says she was yelling about lying. While she was sitting on the phone, while Courtney had her on the phone, while this stabbing is about to happen or already did, Courtney screaming at him that he's lying. So, and that's, I'd really have to, for me to change my mind on that. And I don't know if those journal notes are going to be admissible at trial. I don't know. But that journal note, we're already back in 2021. We have her saying she needs to stop being aggressive. There's the text. I think the text message is going to come into play, where the February text messages, I think I have them handy here. Maybe I can pull them up real quick. February. Let's see. This is probably going to be super tiny on the screen. This long text message is Christian Obumseli, like, at his wit's end. Let me open this in a different window. I hate the way that Google shows it. This is easier to zoom in. But he mentioned somewhere in here, he goes to the hospital because she cuts his face with a knife. This is back in like January 31st of 2022. So just a few months before this April stabbing. He has to get stitches on his face. The cuts are so gross looking. He has to get stitches on his face, and she ends up hitting him a few weeks later while his face is still healing, and it reopens the wound. It like reopens the cut, and it's like gushy and wet because she hits him in the face where he's already stitched up because she took a knife to his face. And in her notes around this time, she's talking about how she got caught cheating with some guy in a bathroom and how she's going to lose Christian Obumseli. So like a lot of these where we have time frames, there's like some physical wound on Christian. There's notes in Courtney Clenney's phone where she's expressing how she's upset and why she's upset. And she presumably thinks she's the only one reading this, right? She's writing this for herself. And she's saying, because I was in a bathroom and I couldn't believe I would have to face the reality when I spoke to Christian the next day. Christian, I'm going to lose him. So there's all this physicality, and then there's all this like weird stuff in her notes. Just crazy, crazy stuff. But yeah, you hear that you cut someone's face, and prior bad acts. I think it's very good that prior bad things, bad character evidence, I slapped someone in a bar fight at karaoke night one day. Should you really be able to bring that in if I murder someone 3-4 years later? It doesn't really seem to be that relevant. But when there's particularity, if I'm doing stuff with knives to the same partner that I end up saying, yeah, I threw a knife at him, seems really relevant. So I don't know if that's something that the defense can successfully argue to keep out. Right? To me, that seems very probative. It seems prejudicial too, but it's more probative than it is prejudicial. It's very particular. So, and Kate says to me, Courtney's journal notes provide a lot of context to what's happening. I agree. And it's not the easiest thing to read. It is a bit triggering, right? I mean, I have never been in situations where it rose to a level like this, but I still have friends that they fought until they were physically separated. Somebody was in jail, right? And like behind the scenes, it's kind of like a behind the scenes look of what someone's writing to themselves, describing events to themselves. So it's an interesting under the hood look. Jazzy T, good to see you. Good to see you, Jazzy T. Tack Clouds out here dropping the slime as Jazzy T drops in here. But yeah, so that's what I've got, you guys. Next hearing is the 25th of June on that. Other than that, I'm not really following too much. I'm watching what Happily Angry Lawyer is talking about. He says he might go live today, but probably tomorrow. Probably tomorrow. So let's see. And I don't think you said... Did you say what you're going to cover? Probably today? If not tomorrow at like 5? Yeah, so I don't see a topic there, but, if it's not going to be about Antonio Sledge or Miles Farley or someone that was in the YSL indictment, it'll probably be adjacent. So maybe the Darren Mills reversal. And maybe not even covering the reversal, but like all of the background stuff. And I'm telling you guys, when you go through the Darren Mills story, or you have a couple stories that you've looked at, Fulton County shenanigans, you're going to hear the familiar names, the familiar faces. Dennis Scheib's going to come up. Brian Steele's going to come up. You guys should learn the name Kyle Winchester. Awesome attorney in Atlanta, Fulton County area. So he helped Darren Mills with his appeal arguments. But I think once you keep his name in mind, you'll start to see Kyle Winchester pop up more and more. Another really good attorney. Okay, I'm going to have to resist calling Catez. I'm going to have to resist calling him Quez. But maybe Catez White's motion for new trial. I've got to get the phonetics on that one. Oh, and this was denied. Interesting. So co-defendant of Darren Mills wins his appeal for a reversal. But his co-defendant's new trial motion was denied like last week. So this is interesting. It'd be cool if you compare both because I didn't follow the details of White's motion. But is it like a different set of facts? Is it different legal arguments that got us to these different outcomes? Is it a little bit of both? Because that's the thing with appeals, you guys. I mean, let's say, for example, Darren Mills and his co-defendants have the exact same set of facts. Hypothetically speaking, I'm sure that's not the case, right? You argue one thing and it doesn't work. Your co-defendant argues another argument, and the court hearing your argument, the appeals court's like, you know what? Yeah, we agree with your argument. Same set of facts, but we agree with your argument. So we're gonna reverse. So we're gonna grant your appeal request here. Always really interesting. Okay, cool. So he's gonna get a new trial anyway because he requested the same relief. So shortest lived victory for the state of all time. There's your caption for tomorrow's stream or today's stream. Guys, make sure. You said 5 p.m. if you go live today. You guys got to go and hit the bell for Happily Angry Lawyer since he's not exactly sure when he's going to pop live. But if you hit the bell, YouTube will tell you like 50% of the time. So there's Happily Angry Lawyer's link in the chat. Dolly Talk was here earlier. I don't know if he's still hanging out. I always love when Dolly shows up when I cover Courtney Clenney because I get to make a he can save her joke. Let's see. Dolly. I already mentioned to you guys the Zachariah Anderson possible actual innocence, likely wrongful conviction case with a panel of people that have followed that case from the beginning. Will be tomorrow over on Excited Utterances channel. Here's Dolly. I think, let me get Flesh of the Gods. I gotta see what he's covering. And this stream, unless someone's live right now and you want me to change the redirect, this stream is going to go to Hella's stream tomorrow, Excited Utterances stream tomorrow, so you guys can hit that notification button. I'm really excited to check that out because it's been a while since I paid attention to that appeal. Excited Utterance, EU, not European Union. Yeah, Jim says once I learn how to schedule a stream. Oh, you're going to do the motion to disqualify prosecutors? For, was that under Darren Mills? Or was that the other case that you mentioned on Twitter? I forget the name, the different case. Take care, Keisha. For always, forever, for life. Thank you so much. Just so glad I caught the live. Really miss you. I know, I miss you guys. Thanks for coming to hang out on this short, sort of unplanned, but kind of planned stream. Really good to see everybody. And then, let's see. Mary W's headed out too. Good to see ya. Is anybody going to watch something live right now before I close this out? It's not really showing me. I just have a bunch of gaming streams that are live right now, so I do think I'm going to leave my redirect on the Zachariah Anderson appeal panel stream. So it'll be awesome. Everybody have an amazing weekend. Maybe see you in streams later today or tomorrow. Hit that bell for Happily Angry Lawyer so you catch him live. With Courtney Clenney, I don't really expect any in-between updates between now and the judge's decision next month. But if I can get a copy of the state's response, we'll talk about that. So waiting to see the formerly very prompt state attorney's office. They're really quick emailing me back with whatever I requested. They kind of been ghosting me the last 2 times I asked for things, but now they're starting to just put things right on the docket. So maybe they'll get it together. We'll see. Other than that, you guys, really awesome to see everyone. Take care. I miss you guys. Hope everyone has a great weekend and catch you somewhere. Bye, guys.